Now we are going to discuss about Article 324. Article 324 is superintendent direction control of election to vested election commission. So election commission conduct all the election of parliament, legislative state and president and vice president. So parliament, legislative assembly, president and vice president or election shall be conducted by the election commission. Composition is the chief election commissioner plus the other election commissioner if any president may from time to think fit. So there shall be two more if president thinking that. In that case, composition is okay. Appointments, all the appointments are made on behalf of parliament by the president. President may also appoint regional commissioner after consultation with the election commission. And service condition of election commissioner and regional commissioner are determined by the president. Services will be determined by the president. Okay, service condition. Okay, chief election commissioner can only be removed in the manner similar to the judge of the Supreme Court. Any other election or regional commissioner shall be removed only on the recommendation of chief election commissioner. So his power is high. And Article 325, no person to be ineligible for the inclusion in or claim to be included in the special electoral roll on ground religion, race, caste, sex. Election to the House of People and the Legislative Assembly of the state to be on the basis of adult suffrage. Article 326, every person who is citizen of India and not less than 18 year age is entitled to register as a voter. Ground of disqualification: non-residence, unsound mind, crime, corrupt or illegal practice. It is the ground of disqualification: non-residence, unsound mind, crime, corrupt and illegal practices. Article 327 is defined power of parliament to make provision with respect to election to the legislature. Parliament may by law make provision preparation of electoral roll, delimitation of constituency and all other matter necessary to ensure due constitution of such houses. Now Article 328, power of legislature of a state to make provision with respect to election or to such legislature. Article 329, bar to interference by the court in electoral matter. Any law relating to the delimitation of the constituency or the allotment of seats shall not be called in question in any court. So delimitation constitution shall not be called in the question in any court. That is important. No election to either house of parliament or either house of legislature of state shall be called in question except by the election petition. There shall be a election petition, then the matter will go to the high court or parliament for the legislation of the election. Okay, next one is National Commission for Scheduled Caste. National Commission for Scheduled Caste. So there shall be a commission for scheduled caste to be known as National Commission for Scheduled Caste. Chairperson, vice chairperson and 3 members will be there. So condition of service, tenure, office determined by the president by rule. Chairman, vice chairman and other members of the commission appointed by the president. Commission has the power to regulate its own procedure also, to investigate and monitor all the matter relating to the safeguarding provided to the scheduled caste, to inquire into a specific complaint with respect to the deprivation of the rights of the safeguard of scheduled caste, to participate and advise on the planning process of socio-economic development of the scheduled caste, to annually submit report upon the working of safeguard of the president, to discharge other function in relation to the protection, welfare and development of advancement of scheduled caste. The president lay the reports before each house of parliament with recommendation. A copy of report is forwarded to the governor if state governor is concerned with the issue. So these all about the National Commission for Scheduled Caste. Now we are going to discuss about National Commission of Scheduled Tribe. Scheduled Tribe, National Commission for Scheduled Tribe, they are similar. The chairperson, vice chairperson and 3 members will be there, and the commission of scheduled tribe to be known as the National Commission for Scheduled Tribe, and condition of services, tenure, office are determined by the president. Chairperson and vice chairperson and member will be appointed by the president, and to investigate the functions are to investigate matter relating to the safeguard providing to the scheduled tribe, to inquire into a specific complaints respect to the deprivation of the right, to participate and advise on the planning process of socio-economic development of ST, to make recommendation to taken the union and state for effective implementation of safeguard, to discharge other function in relation to protection, welfare, development and advancement of scheduled tribe, to president lay the reports before the house of parliament with recommendation. A copy of report is forwarded to the governor if state government is concerned with the issue. Similar? Yeah. Now the language of the union. Language. Article 243 is 343 talks about the language of the union. Official language of the union Hindi and Devanagari. Form of number of official purpose international form of Indian numeral. And 345 talks about official language of the state. Legislature of the state may law adopt any of the more language in use of state Hindi or as a official language until the legislature of state otherwise provide law. The English language shall continue to be used as a official proposal within the state. Article 347 is a special provision relating to the language spoken by the section of population of the state. Language to be used in the Supreme Court and in the High Court. So, and Article 348 talks about the until Parliament by law otherwise provides English shall be used there. All proceeding in the Supreme Court of the every High Court or the bill to be introduced in the amendment of Act passed by the Parliament of the Legislature of the state or all orders, rules and regulation and bylaws. So President and Governor will promulgate the ordinance. So Governor with the consent of President may authorize the use of Hindi or any of the language in the High Court having its principal seat in the state. So these are some articles related to the official language. Emergency provisions. We are discussing now emergency provisions. So Proclamation of the emergency. Article 352 talks about the emergency. President may proclaim emergency if he is satisfied that the grave emergency exists whereby the security of India is threatened by war, external aggression and armed rebellion. War, external aggression and armed rebellion. These three criteria will be there. Okay. So proclamation under the article is commonly known as national emergency. National emergency will be the proclamation. President may declare emergency in respect to whole of India or part of territory specified in the proclamation. Proclamation of the emergency may be varied or revoked subsequent proclamation. The president cannot issue or vary the proclamation unless Union Cabinet communicates such proclamation. Proclamation cease to be operate expiration of 1 month unless before the expiration of date period it has been approved by resolution of both the House of Parliament. So 1 month will be required to proclamation, then it will pass by both the House of Parliament. Okay. Proclamation shall cease to operate expiration of 30 days from the date of which the House of People first sit after reconsideration. So there will be the House of People. He will again reconstitution will be there. So 30 days will be given to the proclamation. Okay. So proclamation shall cease to be operate at the expiration of 30 days. Dissolution of House of the People take place during this period of 1 month. Only 1 month is for the dissolution of House of People and proclamation is issued at the time when the House of People has been dissolved. Then resolution approved in the proclamation has been passed by the Council of State but not passed by the House of People. So a proclamation is valid for the 6 months from the date of passing the second resolution. So it is the 6 month given for the total resolution. Special sitting of the House held if 1/10 of total member of the House of the People move a resolution for the disapproving the proclamation. So 6 months has been given. Resolution has been given to the speaker of if the House is session, to the president if the House is not session. If so, speaker will take the resolution if the House in session and president if House is not in session. Special sitting of the House shall be held within the 14 days from the receipt of such notice by the speaker of the president. So speaker in the 14 days will give the resolution to the president, then he will go for the resolution. So to speaker, if House is in session, if there is a session in the House, the speaker will give the resolution. If there is not in session, then the president will give this resolution. Okay. Now Article 353 is the effect of proclamation. The executive power of the union shall extend to the giving of direction to the any state. The power of parliament to make law respect to any matter extend beyond the union list. So the power will be improved in during the national emergency. So proclamation of emergency will increase the power of the union in respect to the states. Article 354 talks about the application of provision relating to the distribution of revenue while proclamation of emergencies operation. So distribution of revenue is given in the 354. Article 355, it is the duty of the union to protect state against external aggression and internal disturbances. Provision in case of failure of constitutional machinery, president or receipt of a report from the governor and proclaim if he is satisfied that the governor of the state cannot be carried on the accordance of the provision of the constitution, then there shall be a national emergency. The president may by it's a presidential rule. So president may by, like, it's a article 356. Okay, so in article 356, president may by proclamation assume to himself all or any of the function of the government of the state and power of the governor, declare that the power of the legislature of the state shall be exercised by the under the authority of parliament, make provision for suspending involved in the part of operation of any provision of constitution relating to any body of authority of the state. President cannot assume to himself any of the power vested in excessively by the High Court. So President cannot assume to himself any of the power vested in or exercisable by the High Court, and President cannot suspend in whole or part of the operation of any provision of the Constitution relating to the High Court. In High Court matters, President do not have the powers, otherwise he has the powers. Proclamation shall be to operate at the expiration of 30 days, the date of which the House of the People first sits after its reconstitution. So proclamation ceased to operate at the expiration of 2 months. In the case of the governor rule, there shall be a 2 months proclamation in the presidential rule. Okay, and before the expiration of the period, it has approved by the resolution of House of Parliament. Both House of Parliament should pass by the resolution. So after then, that this will be for the 3 years only, but the national emergency can be for the unlimited time, but the presidential rule shall be for the 3 years. So no such proclamation shall in any case remain in force of more than 3 years, and the resolution to continue the force of the proclamation beyond the expiration of 1 year shall not be passed by either House of Parliament. A proclamation of emergency is in operation in the whole of the India or any part of the state at the time of passing such resolution. Election Commission certified that the continuation in the form of proclamation is necessary. Okay, so 357 is given for the exercise of legislative power under the proclamation issued by the 356, and power of the legislation of the state are exercised by the under the authority of parliament. Suspension of provision of article 19 during the emergency. 358 talks about the suspension of article 19 during the emergency. And fundamental rights are suspended automatically during the national emergency except emergency due to armed rebellion. So in the armed rebellion there will never be suspension of power, but in other matters there shall be a suspension of powers. Article 359, enforcement of the right conferred under the Article 111 are suspended during the emergency. Part 3rd is suspended. Part 3rd will be suspended during the emergency. The fundamental right, whole fundamental right will be suspended during the emergency. Right under the Article 20 and 21 are not restricted. Like in Article 359 it's given like 20 and 21 are not restricted for that. Okay. And a provision of the financial emergency is given in Article 360. So what given? It's given President may proclaim emergency if the financial stability or the credit of the India of the any part of the territory is threatened. So proclamation may be revoked or varied by the subsequent proclamation, shall be laid before each House of Parliament, shall cease to operate at the expiration of 2 months, not approved by the resolution of both House of Parliament. So in such a direction include a provision required to reduction of salary allowances of all classes of person, reservation of money bill or other bill for the consideration of the president. Okay, the money bill shall be in the reconsideration of president, and a provision requiring the reduction of salary and allowances of all class of person. Even the Supreme Court and High Court judge also, their salary will be reduced in that. President may issue direction for the reduction of salary and allowances of all the any class of person serving in the union, including the judge of Supreme Court and High Court. Okay. So what I provided here. Now we are